On March 30, 2026, the Knesset passes, by 62 votes to 48, a law establishing capital punishment for acts classified as terrorism. Netanyahu travels to Parliament in person to cast his vote. Gvir, who authored the bill, wears a golden noose-shaped brooch in the chamber, a campaign symbol he saw no reason to conceal. The law provides for hanging within 90 days, with no appeal, no clemency, decided by a simple majority of judges. It applies to Palestinians in the West Bank, tried before military courts with a conviction rate above 99%. That figure is worth pausing on. 99% is the rate of a system that no longer needs to weigh guilt, because guilt has already been decided upstream. Israeli settlers committing the same acts in the same territory fall under civil law. Israel had executed only one person since its founding, Adolf Eichmann, in 1962, 64 years of restraint. The law isn't called the abolition of that restraint, it's called an extension. Cesare Beccaria published his treatise in 1764, at 26, anonymously, out of fear of the Inquisition. What made it dangerous wasn't a revolutionary political idea, it was something closer to arithmetic. If two people commit the same act, they receive the same punishment, nothing more. Equality of punishment isn't one value among others in Beccaria. It's the condition without which the word law means nothing, because a rule that doesn't apply to everyone is a preference, not a rule. That framework survived 2.5 centuries, and it was precisely this framework that the legal architects of the Eichmann trial invoked to justify Israel trying a Nazi captured in Argentina. One law for Eichmann in the name of universality, another law in 2026 in the name of belonging. The law was presented as a response to October 7, 2023, but it will not apply to the perpetrators of October 7, 2023. The text is explicitly non-retroactive. This isn't a drafting oversight. A text that claims to punish a crime but excludes its most emblematic perpetrators reveals its true nature. It doesn't target past acts. It equips a regime for future ones. In the occupied West Bank, Palestinians appear before military courts, whose primary function is not to establish guilt, but to maintain order in a territory under occupation. It is within that framework that capital punishment becomes the default sanction. Ram Ben Barak, former deputy director of Mossad, said on the floor that this law is a defeat, not a moral one, but a strategic one, because it reduces Israel's capacity to negotiate for hostages. He didn't speak of justice, he spoke of efficiency. In hydraulics, a check valve doesn't think. That's precisely its value. It responds to direction, not to content. It doesn't know what the fluid carries, it only knows which way it's arriving. What engineers value in this device is its automaticity. No decision required, no arbitration, the mechanism does the work. What legal theorists dread in a law built on the same principle is exactly the same thing, when capital punishment is triggered not by what one has done, but by what one is. When belonging replaces the act as the determining criterion, law becomes hydraulic. It no longer delivers justice, it manages flow. In 1962, Eichmann is hanged at Ramla prison. His body is cremated, his ashes scattered at sea, beyond Israeli territorial waters, so that no grave would exist, no site of memory or pilgrimage. The state took the trouble to erase him after suppressing him. 64 years later, the law provides for executions within 90 days, repeatable, routine, with no clemency possible. The relationship to time is inverted. Where Eichmann had been an exception handled with solemn deliberateness, the new procedure is designed to be fast, administrable, reproducible. What Israel had reserved for the singular has been transformed into an everyday instrument. The difference between an execution and a policy of executions is not a question of degree. It is a question of nature.